Assalamualaikum teman-teman Juwaria. I am Sarah Khaira and I will be presenting on my case study, which is Affin Bank Berhad versus Zulkifli bin Abdullah. So in this presentation, there will be 4 sessions. Firstly, which is the facts, concluding what happened in the case. Second is the issues, which are 4 issues that I identified in the case. Third is the court's ruling, which is the decision by the court. And fourth is the rationale of the case, which is the summary and also the significance of the case. Okay, so firstly, I will be talking about the facts in the case study. Firstly, the defendant, Zulkifli, paid RM 385,000 for a double-story corner-link house for the vendor, plus RM 39,000 as a deposit. For the remaining 346,000, he obtained an Islamic financing facility from the plaintiff, his employer, Affin Bank Berhad, through by Bitaman Ajil. The plaintiff agreed that and granted the facility under the 1997 agreement, which is consisting of 216 monthly installments over an 18-year period. Next, the defendant later resigned from the plaintiff bank and requested that the facility will be revised and restructured, resulting in a bank selling price of RM 992,363.40. There was, however, no new set of documents executed. The defendant defaulted in making the payment after making a few payments totaling of 33,454.19, the last of which was made on June 5th, 2001. And as a result, the plaintiff filed a notice of default under the section of 16D of the National Land Code requesting a repayment of 958,997.94. Following that, the plaintiff filed 2 more actions. Firstly, they obtained an order for sale, and secondly, to recover the sums in the event that the proceeds of sales are insufficient to repay the amount claimed by the plaintiff. The plaintiff sought RM 958,909.21 in damages because the defendant had already paid 33,454.19. Okay, so there are 4 issues identified in the case. Firstly, validity of 1999 revision. Secondly, 1997 facility. Thirdly, amount claimable. And fourthly, conversion onto sale price. So we will be looking into each issues. So the first issue is the validity of 1999 revision. According to the facts, 2 facilities were granted under the BBA facility in 1997, and it was later revised in 1999. The question is the revision correct? And in this case, it is clear that the bank and the defendant did not sign a new sale and purchase agreement specifying the new sale price. The only document between the defendant and the bank was a letter dated November 1, 1999, which required the signing of a new set of documents, but there was no document signed. And on top of that, it is worth noting that in Islamic Bank, the bank's issuance of a new letter of offer does not constitute an underlying transaction between the bank and the defendant on its own. BBA was never intended to be a strict financing instrument. It is a sale and purchase transaction, and as a result, BBA must be treated as sales contract rather than financial instruments. A sale is an exchange contract that entails the exchange of goods and their counter value. It can be concluded that there was no valid sale concluded between the bank and the defendant in 1999 in the absence of any contract of exchange, or in this case, a new sale and purchase agreement signed between the bank and the defendant. On top of that, the bank and defendant should have mutually terminated the 1997 facility when the defendant requested it to be restructured, requiring the defendant to pay the sale price immediately. The bank and defendant will then enter into a new BBA transaction at the revised sale price, with a portion of the revised sale price going towards paying off the 1997 facility. And as a result, the excess money accepted by the bank over and above the original sale price without a valid underlying transaction is considered as riba. And the bank is not entitled to receive it as it involved with riba. And it is also important to note that the most important characteristic of Islamic banking is that it must be interest-free, which is riba is always prohibited in Islam. Okay, so moving on to the next issue, which is the 1997 facility. In this facility, the bank purchased the property of 346,000 and simultaneously sold it to the defendant for a sale price on deferred payment of 3,582.80 cents, payable in 216 installments of 3,582 ringgit and 80 plus an IBRA of 1,421 and 47 cents, as long as the defendant remained as an employee of the bank. At 3,582 ringgit and 80 cents per month, the total amount payable by the defendant over 216 months would be 773,884 ringgit. However, the bank selling price was set to 466,847.28 cents in the document signed between the bank and the defendant. Once a selling price has been agreed upon, it becomes a legally binding agreement between the bank and the defendant, and the house price cannot be changed. So the third issue would be the amount claimable. What is the amount claimable by the bank? Is it 773,884 ringgit or 466,847 ringgit? And the bank is free to grant IBRA, which is essentially a debt forgiveness, or is known as a rebate. It refers to a creditor's action of forgiving a debtor's or buyer's debt, thereby releasing the debtor from his debt or his or her debt obligation. IBRA can be carried out unilaterally, and the debtor's cooperation is not required. A debtor, on the other hand, has the option of refusing to accept the rebate. IBRA is normally given to a customer who is not delinquent because it is discretionary and given at the sole discretion of the bank. However, in this case, where the bank agreed to a sale price of 466,847 ringgit, it is reasonable to assume that the bank has released the defendant from any obligations in excess of the amount, especially in the absence of any evidence of the defendant's refusal to accept the IBRA. And the last issue is the confusion onto sale price. Can the bank insist the selling price of the house at RM 773,884.80 cents on the basis that this was the price payable by the defendant, and the IBRA will only be applicable as long as the defendant was under the employment of the bank? So to avoid gharar in Islam, there must be certain. When a bank sets two prices for a house, one for as long as the buyer is employed by the bank and another for when the buyer leaves, the price of the house becomes uncertain, which is forbidden in Islam and could jeopardize the sales validity. So when the defendant agreed to buy the house for 466,847 ringgit, the sale price became a debt that the defendant owed to the bank. Despite the fact that the sale price is payable in installments, the defendant is only granted a privilege as long as he does not default on the installment payment. And when the defendant fails to pay an installment, the bank has the right to demand the entire sale price be paid in one lump sum, as it is the contractual sum that the defendant agreed to pay to the bank. The bank has absolute right to claim the contractual amount of 466,847 ringgit because it is a sale price of a valid contract, and there is no question whether it is unearned profit or not. And with all due respect, separating the sale price of the house into unearned profit for the unexpired tenure in the event the bank decided to seek a lump sum payment upon a customer's default is unjustifiable under Sharia. So next, I will be talking about the court's holding. So Abdul Wahab Patel J, which is the judge in this case, held to grant the order for sale and reduce the repayment amount. According to the court, the customer is entitled to benefits for the duration of the loan repayment if he chooses to do so. The bank, on the other hand, cannot claim the profit margin for the full tenure if the customer chooses to pay the full tenure instead of the agreed upon tenure earlier. This is because if the bank collects the profit margin for the remaining tenure, it will earn twice as much from the original sum. In terms of collecting the unexpired tenure profit, it actually goes against the BBA principle. This is due to the fact that the bank does not earn the profit collected for the remaining term. As a result, it was against the law and the bank was unable to collect it as a compensation for the loan. The court also states that an order for sale can be issued unless there is a compelling reason not to. And this is due to the charge being in an ad rem right to sell the security in order to recover a secured debt. Okay, for the rationale or the reasoning, the application of by bitaman ajil BBA between the plaintiff and the defendant is primarily the focus of this case. The plaintiff has provided the defendant with a BBA facility for the purchase of a two-story link house. In regards to end of the tenure, the learned judge points out that there is an element of surprise in the BBA facility. This is because plaintiff still owes the bank a substantial sum even after the subject matter has been auctioned at a full market value. It is also claimed that a borrower from a traditional bank is in a better position than a customer who uses the BBA facility. The consequence of a default under the BBA facility is proved to be more burdensome to the customers. So the reasoning behind this case is that the learned judge was able to recognize the inadequacy of BBA principles in terms of full tenure. The judge does point out that the profit margin that was charged during the unexpired portion of the tenure cannot be considered actual profit. The BBA facility does not allow for the claim of unearned profit. In this case, the judge was also able to emphasize the applicability of the law that govern the dispute. There is no difference in the application of law if the dispute is over Islamic facility documents. In other words, if a disagreement between parties arises over a facility document, both Islamic and conventional banking will be governed by written law. In this case, the issue of law is the interpretation and application of the terms of the contractual documents between the parties. Therefore, the same law will be applied and the court will not be required to refer to another forum. And as a result of the judge's meticulous care in pointing out the relevant rationale and problems in regards to the implementation and the enforcement of Islamic bank facilities, this case can serve as a stepping stone for future cases. Okay, so that is all from me. Thank you so much.